You solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
Yes, sir.
Yes.
I'm not going to lie. I've been doing this for 30 years, and this is the first time I've ever seen the Attorney General's office file a lawsuit to throw out one of its own default orders. They have filed a bill of review, which is a sideways attack on an order that I signed several months ago. It is strange for the AG's office to file a sideways attack against its own court order. What they state in this bill of review is that Miss Wallace has provided them proof that she was not personally served on the modification suit. Miss Alexander, you represent the state of Texas.
Yes, Your Honor.
Have you had an opportunity to review the evidence that Miss Wallace has sent to the state regarding this citation?
Yes, I do, Your Honor. This states that she was served at 8:33 a.m. on August 26, 2022. However, Miss Wallace provided information that she clocked in at her employer at 7:57 a.m. and did not leave until 2:08 p.m., then clocked back in at 2:40.
Okay. Well, Mr. Walker, what says you? I mean, what it's like I say, I've never seen the state file a lawsuit to overturn their own court order. So it sounds like there's pretty good evidence that the process server on this case did not actually serve Miss Wallace with the lawsuit. So I didn't have the right or the jurisdiction to grant this modification. What do you say about that?
I think I filed for the modification December of 21.
Okay.
I probably didn't. Yes, sir. But I'm just trying to get up to the point, up to the time around that time. I probably got a notice back about it 6 months later, and then I got a review maybe when it was July maybe, and it didn't even take effect right then and there. When she gave me a review, because I was at Louise's house, I actually was there with my kids when I did the phone hearing. She knew about it. Went to work that day. I was at her house that day of the hearing. I told the lady her bedroom, and it didn't even take effect for another 3 months. And I was trying to explain to her, like, I'm not working for the same company. The company I was working for, and Louise knew this because she's seen a couple of my checks.
Okay.
I wasn't making any money. They was taking everything for child support.
What?
I'm work for a whole week and bringing home $80-something every now and then. Not all the time, but a bit of the times. And a couple of times I did manage to make some money, sir. But I'm trying to figure out, because I don't live.
Mr. Walker, I'm going to believe everything that you just said is true. I'm not even going to think about what you just said not being true. Everything you just said is absolutely true. Okay. It doesn't change anything. When you leave it up to a state agency to fix your child support issue, then you are at their mercy as far as how long it takes them to get it done, how long it takes them to serve people, whether or not everybody in the lawsuit is going to cooperate with your efforts. You left it to the AG's office to take care of this problem. So you are at their mercy as far as how long it takes them to finish it. Okay. And while I completely understand everything you just said, the simple fact of the matter is Miss Wallace did not participate in the lawsuit that I did last year in this case, simply because she didn't know the lawsuit existed formally. She may have been getting phone calls. You may have been trying to tell her for months that you were trying to get your child support fixed. All of that may be true. In order for me to sign a court order against Miss Wallace, somebody has to physically go out and put papers in her hand to give me, the judge, the court, the right to change your child support. You understand? And they didn't do that in this case. We thought they did because they filed an affidavit saying they did, but they didn't. Okay. I'm going to grant the bill of review, Miss Alexander. I don't have a choice. It's a service issue. If Miss Wallace was not personally served, then the judgment is invalid. It's not any good. It's not worth the paper it's written on.
Yeah.
But Miss Wallace is served now.
Yes.
Absolutely.
You understand that you have now appeared formally in my court, so you are served with this modification suit.
Yes, I was.
When's our reset date, Miss Alexander, so I can hear?
Let's do, what are we on? Let's do April 13th, Judge.
April the 13th.
Yes.
All right. So this is what's going to happen now. Miss Alexander is going to send me an order that grants the bill of review. That's the sideways attack on their order. And then I'll sign that, get it back to them. They'll file it. That will reopen the original modification suit that was filed last year. And we are going to come back here on April the 13th of 2023, which is only a couple weeks away. And we'll try that modification suit at that time. Okay.
Okay.
All right. The AG's office will send you notice of that hearing date so you know what the Zoom number is. Miss Alexander, how do you intend to send that notice?
It will either be by mail or email.
Just watch your mail or watch your email for the Zoom information for that hearing date in April, okay?
Okay.
Yes, sir. I just need to make sure because I actually received 3 different forms. Like I was emailed that yesterday was my hearing. I have 2 letters stating today was my hearing, one at 9 o'clock and one at 10 o'clock.
Okay.
I got 3 different. I called.
Well, I'm telling you right now, Mr. Walker, it's April the 13th that you will get one. I mean, I don't know why they may have sent you 2 notices for the different times, just because we're kind of going through some minor changes on how we're running our dockets, but it will probably start at 9 o'clock. They'll bring you in and try to negotiate your case, and hearings will start at 10 an hour later. All right. I wish you both the best of luck. You're both free to go.
All right, this is your objection to a child support modification, is that correct?
Yes, Your Honor.
And what is your reasoning for objecting?
I believe that it was too much. Sorry, I can't find words. The amount that they came up with was, I believe it's too much. I'm not trying to cripple the man.
Well, do you believe it was improperly calculated, or
I think it's a little too high.
All right, why do you believe it's too high?
He does have only one job. It seems like a lot.
Is it accurate that, so it was based on him having about 65 overnights with the kids?
Yeah, more or less.
Do you provide anything else outside of that financially to the children?
The main healthcare. I have Medicaid as a secondary to cover some of the higher co-pays for the girls. And he regularly sends them money through Cash App, like $20, $40 weekly, bi-weekly.
What do you feel is an appropriate amount per child?
The girls and I discussed it, and we feel between $300 and $350 per child seems a little more fair.
All right, well, given mom's testimony regarding this matter, her request to reduce the amount of support, her testimony that dad does provide some direct payments to the children as well as insurance, I will grant the request and make the support at $350 per child plus the ordinary medical. Any questions from the front of the? All right, thank you. That change will be made and sent out to the both of you, ma'am.
Thank you.